Welcome to the Neighborhood Law Center. I'm your host, Melvin Burris, and today we have with us as our guests is Sue Moffett and Mario Salas. Welcome.
Thank you.
Thanks.
Okay. Our program today is entitled Impact of Court Debt on You, the Public. But before we get started, I would like for our guests to say a word or two about themselves. Okay, Sue, would you get
Sure.
started?
Thank you for having us. I'm Sue Moffett. I'm the Assistant Director at the Charlottesville Department of Social Services, and I chair the Community Reentry Council.
And I'm Mario Salas. I'm an attorney with the Legal Aid Justice Center. I also sit on the Reentry Council with Sue and Mel, and I accept cases for people who have faced negative consequences because of their court debt.
Okay, let's get on with the program. I'm going to get started with saying many states are imposing new and often onerous court fees on individuals with criminal convictions. Yet far from being easy money, these fees impose severe, often hitting costs on communities, taxpayers, and indigent people convicted of crimes. They create a new path to prison for those unable to pay their debts and make it harder to find employment and housing, as well to meet child support obligations. And so with that in mind, we're going to let Mario Counselor give us an overview of the impact of court debt on our individuals. Go ahead.
So thanks. Yeah, we thought it would be helpful to kind of go through a description of how the system works. I think the easiest way to sum it up is that, believe it or not, you have to pay for the privilege of going through the criminal or traffic justice system in Virginia and in lots of other states. When we talk about court debt, we're talking specifically about court costs, which are the administrative sort of fees associated with going through court, and also penalties, so fines, restitution, other kinds of penalties. So I want to keep those two categories in mind: administrative costs, kind of repaying the system for its time and services, but also the more punitive element, the fine that is supposed to be deterring you from doing the bad thing in the future. So just an example, you get a speeding ticket, you go to court and you want to contest it, and you end up losing. So you're going to get assessed some lump sum of money. Part of that's going to be just from the cost, the administration of the court time, but also the deterrent factor, sort of that fine that goes along with it. Again, the idea that the penalty is going to deter you from doing the bad thing, again, speeding in this example. So just some examples of things that costs can go for, that you'd have to pay for, at least in a general district court, kind of the low-level traffic court and also low-level criminal court. Blood withdrawal fee, they'll pay you for taking your blood, charge you for taking your blood. That's not to exceed $25. The jail admissions fee, so you pay for your ticket into jail, also not going to exceed $25. And the courthouse maintenance fee, so chip in to keeping the paint looking pretty. That's a $2 max per charge. That can add up too. I think people are really surprised to learn about the next one. You always hear about, if you can't afford a lawyer, one will be provided for you. What they don't tell you is that if you can't afford a lawyer and one is provided, and then you lose at your trial, you're going to have to pay back that lawyer's time. There's a flat amount for that, which can go up or down, and it's going to be higher for certain types of crimes. And that's actually true in lots of states, but not all states do what Virginia does to make sure that those debts get paid. So let me just take a second to talk more about how the costs and fines are scaled. The best analogy I can think of is that it's kind of like walking through a cafeteria line, and except everything is already picked out for you, and it's just based on what you're wearing when you walk into the line. Okay, so let me put that in kind of real terms. The law says that if you're found guilty of a criminal or traffic offense, then the clerk of the court is supposed to make up a statement of the costs that are associated. So again, keeping the cost idea different from the fines idea. So they kind of go down the list and say, okay, well, in the administration of this case, we did this, this, and this. Some of those are going to be standard. Others are going to only come in for certain types of crimes or traffic offenses. And then you just kind of get a total at the end. So it's like picking off of a menu. And that goes right to the judge. It's ordered. It has the effect of a judgment, and that then takes effect against the defendant that lost. Fines work a little bit differently. So again, the distinction between penalties and costs, the fines and other penalties are clearer in the statutes. So let's say the law says that this is a class 1 misdemeanor, what we found you guilty of. It'll set a high, like a ceiling as to what the judge is able to penalize you in terms of money amount. So, it could be up to $500. Okay, well then the judge will take into account various things in setting the fine at that level. So you'd have a fine that can go up to $500 or more, for example. I'm just pulling these examples kind of out, along with the costs. Okay, so those two things together, and then you might have restitution in certain cases, other kinds of penalties, are all lumped together in what we call court debt, because it has the effect of a debt, just like any other, except the state actually has more power to enforce its debt than other types of creditors might. So I can get into that in a second, but I just wanted to talk now about what can happen if somebody's not able to pay off their court debt. So let's say you get a bill from the court. Your costs and fines in this case were $200, let's say, and you can't pay that day. What happens to you? Well, actually, the law gives you. So far, this hasn't been all that controversial. It seems sort of standard, but this is where it's going to start to get kind of ugly. So just bear with me. You have the statute set a window of time when you can come in and pay in full. You don't have to pay that day. You have about roughly 40 days to pay it. What happens if you get to the end of that time and you still can't pay it? Well, I'll get into this in a little bit of a second, but Virginia's #1 tool for trying to get people to pay their court debt, for enforcing the debt, is to take away their driver's license until they can pay. The argument in favor of that is that, people care about their driver's licenses, they want to protect it, they want to get it back, so they're going to have this motivation to come into court and pay for it. Well, of course, what ends up happening is that this just ends up making a bad situation worse, right? Shockingly, and I'm being very sarcastic with that, it turns out that if you take somebody's driver's license away, it's also taking away their ability to get money to pay towards this debt and other debts and all the other daily expenses of living. Virginia's enforcement mechanism, let's just say, has some negative consequences.
Okay, so they take my license away, then I can't go to my job. Can't get to my job. I don't get paid, and there's a vicious cycle. Sue, could you talk on this, the impact here?
You're exactly right about that. Not only can you not get to your job so that you can't get paid, you may also decide, well, you need to get to your job, so you're going to drive on a suspended license, which just compounds your legal issues and increases the court debt that you're ultimately going to be responsible for. And it's not just employment, right? Because it also can have effect on the types of jobs you get besides getting to your job. But how do you interact with your family and your community? How do you get to the grocery store if you have no driver's license and you can't drive?
And then are there any ways the courts can lessen this or make it easier to pay the court debt down?
Yeah, so there's actually a few ways. Let me just bring up an example, and that might help us to kind of wrap our brains around the ways that courts make it easier, or maybe could make it even easier. Let's just say you go to court because you've got a busted taillight, and you want to go and contest the charge because you feel like you shouldn't have to pay for that because you don't have the money to pay for it right now. You feel like you have a legitimate excuse. And it's a problem, you recognize that you did something wrong, but you just want to make your case before the judge that you should have more time to kind of fix your taillight. It's been let's just say you've been unemployed for a long period of time, and you're just really scraping by to kind of make ends meet. Let's just say other benefits like food stamps and other things have run out, and so you're just day to day, right? So you go and you plead your case before the judge. Judge is not all that sympathetic to you and decides that you've got to pay anyway for your violation of the traffic law requiring us all to keep good working headlights and taillights on our cars. So this is pretty low. There's a $30 fine max associated with that, and some costs. Again, the sort of penalty and then the cost distinction. But what in your eyes, it's you got to pay $40 no matter what. For lots of us, this is easy. We can pony up $40. It's not going to be the end of the world. But I mean, again, go back to my example. You're just on really hard times. You've never been able to make it. You've been scraping by your whole life. Your $40 might as well be $4,000. There's nobody around to kind of help you. You have no options. Well, there is some option, I guess. So one thing I just want to say is that let's just say you're not able to pay the $40 by the end of that 40-day window. Your license gets automatically suspended. Then to get your license turned back on, you've got to go back to DMV. And, well, assuming you take care of all the other reasons, go back to DMV and pay a reinstatement fee, too. That's like a reactivation fee. You know, you get your electricity turned off, you pay to get it turned back on. Same kind of idea. That runs about $140 and can go up from there. So you see how a $40 ticket turns into almost $200 ticket after if you have not been able to pay within that 40-day window. You know, what I've been kind of talking around is what is this repayment option, right? So you either can pay in full or you can get onto a payment plan. Every court is required to have a payment plan to ostensibly make this process easier for folks to take care of. And in theory, I guess that works. You know, if there's a payment plan, it makes the burden a little less harsh to deal with kind of up front. You know, I mean, the huge problem that we see is that lots and lots of courts in the state, and again, we're just talking about state courts here, we're not talking about the federal, just Virginia state courts, have payment plan policies that actually make it really hard for people to get onto the payment plan and stick with it. So, you know, one thing I should say is that every court is kind of like its own little kingdom. It keeps its own books with regard to the debts that are out there for costs and fines, and they all handle things a little bit differently, or in some cases a lot differently. So you might have what's true in one court is definitely not true in other courts. You kind of have to learn what the ins and outs are for each one. You know, examples of some kind of terms I've seen, minimum down payments that are not keyed to a person's ability to pay or to the size of the debt. So just a blanket policy that says you've got to pay X amount to get onto the payment plan. Monthly payments that are set at the total amount of the percentage of the amount of the debt and not what the person can realistically pay. So that might be 10% of a $500 debt, let's say. That's a $50 monthly payment. Well, the court's not looking at the person's ability to pay that, just the size of the debt. Other things, you know, time limitations, windows after which you can't get onto a payment plan. So all of these variations and lack of uniformity lead to lots of problems. I mean, number one is that if you have debt in one court, you might be closed out from getting onto a plan, period. Let's just say you owe debt in multiple courts, which is absolutely not out of the ordinary in my experience. In fact, our understanding is that that's the norm. People who owe are going to owe in more than one place. I mean, especially in a place like Charlottesville, we go in and out of the county all the time. We're all around the area. You can get a traffic ticket or other thing just as easily there, too. So imagine if you're kind of juggling multiple debts in multiple jurisdictions. There's no one-stop shop for payment. You've got to go to every single one and, you know, along the lines of their own payment plan policies, which could be hugely different. So that's where I come in. That's what I help clients to understand their kind of situation and to develop a strategy to make it through that. It might take years for that person, but honestly, right now, the current landscape of the law is so difficult that people just do not have realistic options sometimes for getting their license back.
Okay. Well, let me ask Sue, Assistant Director of Social Services, does the Social Service Department have any services that they can help these people out with once they get in this situation?
That's a great question. While there's no real program or services specifically designed for prisoner reentry or to support ex-offenders, many ex-offenders are eligible for the traditional public assistance programs or social services that we do offer. And what it really requires is that we be a partner with other service providers and legal assistance providers in the community to make sure that people that are eligible for mainstream programs and services get hooked in.
Okay.
a good example that Mario just alluded to is if you have debt obligations in multiple courts, but you don't have a checking account because you've never been banked, we can help you find resources to set yourself up and get a bank account.
Okay, so give us an example of that, if that's possible.
Well, there's a wonderful program that's operated out of the Charlottesville Downtown Job Center called Bank On, and that is their mission. And Mario can talk a little bit about that too, but to help people become banked, have a way to, a mainstream way to settle their debts,
Okay.
as opposed to money orders.
So, Counselor, tell us about some real life experience that you may have had. This is your job. This
Sure.
is what you do. You assist people in these situations,
Yep.
whether they're ex-felons, reentry, or someone just lost their license and had an accident or went to court for a speeding ticket. Give us an example of some of these so we can kind of make it personal.
Yeah, I want to take a step back from making it personal and probably make it about as impersonal as I can. We need to keep in mind this is not just a problem that impacts a few people in the state. This is an issue that is impacting literally hundreds of thousands of drivers in Virginia today. We have data that show from the last fiscal year in 2015, just alone, DMV issued roughly 350,000 new orders of suspension because of unpaid costs and fines and other types of penalties.
Okay, can you hold that thought for a minute?
Yeah.
I just want to let our audience know that this is the Neighborhood Law Center. I'm your host, Melvin Burris, and our guests are Assistant Director of Social Services, Sue Moffitt, and Attorney Mario Salas. And our program today is the impact of court debt on you, the public. So, Counselor, could you get back to what we were talking about?
Yeah, so I was just mentioning that this is a problem that's impacting hundreds of thousands of drivers. You look at how many drivers are in Virginia licensed right now, it's roughly 6 million. I mean, if we think that if we know there were 350,000 new orders just last year alone, and that's just new in that 1 year. There's orders that are going back that have been in existence for, 5, 6, 7, 8 years. Clearly we can extrapolate from that number and see that this is a huge problem that's impacting a large proportion of drivers in Virginia today.
And let me just jump in with some local data. At the Charlottesville-Albemarle Regional Jail, in the same time period, there were 420 bookings for driving on a suspended operator's license with an average length of stay of 9 bed nights.
Yep.
So it's about 10% of the
10%.
bookings there in any given year.
So, which means that there are administrative costs associated with that as well as fines associated with that.
That's one of the challenges with this because a direct nexus is a little bit murky because some of those costs for the jail are set costs. They need a certain, their electricity is the same, they have their housekeeping costs are the same. So it's harder to make a direct connection to that, but it's obviously a logical one that if we can take care of this problem, the cost of incarcerating people, at least locally, should go down.
Which have a big savings upon the county and the city itself.
Yeah, I do want to get to the example. I have a few of them, but let me just take that point a little bit further and say that there's other costs that are associated that we can think of as wasteful that the courts are incurring in chasing after these just dead debts. Because imagine that people that are entering the court system, a large proportion of them are not going to have the ability to pay this off right away, or maybe even in 5 years or ever. Still, they routinely get assessed the debt because in Virginia, we have no mechanism in the law right now that requires courts to look at a person's ability to pay before imposing the cost. This goes back to the point I was making earlier about kind of picking from that menu. Nowhere do they ever look at well, can this person actually pay that, okay? So what you see is out of the pipeline, what's coming out of it are just lots of these debts that are never going to be collected on. And yet we have clerks taking time to go after them. We have courts hiring collections agencies to do collections on their behalf. We have people going into jail who get locked up because they've been driving on a suspended license, which is not out of the ordinary in any way. People needed to get around. And so there's all of these hidden costs. And so Sue is absolutely right that it's hard to kind of quantify what they are, but you just think about all the time, money, energy spent on chasing after these low-income defendants. just to not be able to get anything, just to and still their license is suspended all throughout this entire time. So there's another cost, right? They're not paying taxes, they're not employed maybe, so just it sort of spirals, right? But I do want to get back to the specific example because you asked me about that, and I do have a couple in mind. One particularly sad case that I saw pretty early on in my work on this project was a client who came through our office living in a rural jurisdiction, which, the closest town to where this client lived was, 15 miles away, kind of in the middle. This is not out of the ordinary from around here, right? They're driving one day and just get a speeding ticket. I can't remember. It was a speeding ticket, something very kind of minor, what we all do, right? But for this client, this is what really started the cascade. This client shortly after that was laid off from their job, and so was unable to pay the costs and fines associated with this just routine kind of, low-level traffic ticket. Without a job, this person was not able to get benefits, food stamps and other types of benefits. And so you can start to see how the income pool that this person had to pay the debt shrinking slowly. And so they've gotten laid off from their job. They have no driver's license to get a new job. They live in the middle of nowhere. And so some people say, well, what about community service? That might be an option for this person. Why can't we do that? And it's true that the law allows community service, in fact, requires courts to have a community service plan, but not all courts actually have to make the plan available. They just have it. And there's also problems with, from my perspective, community service, because people, if you spend your time doing community service, cleaning up your, local courthouse, you're not spending time working, right? And that's what we should be focusing on. I'll kind of put that to the side for a second to get back to the example. But the person continued to drive, as we all, have to, especially if we live in a rural jurisdiction where there is no public transportation. This person was effectively homebound because of the license suspension, and so continued to drive to get to medical appointments, job interviews, other things. Got a traffic violation citation for defective equipment. I think it was like bald tires or busted taillights, something like that. Something, of course, that this person couldn't correct because they didn't have any income,
Right.
because they lost their job and couldn't get one, right? And so the spiral starts to get deeper and deeper and deeper. And the court costs and fines go higher and higher. So every time this person was in court, they're getting more and more debt. By the end of it, after 3 years, I believe the debt was around $2,000. So it had grown from sort of one, pot, 150, I think it was, to almost 200. The other thing is that interest is accruing on these debts the entire time, so they're getting bigger.
Is penalties a part of that, or is it?
They're not. There's no penalty on non-payment. The penalty is the driver's license suspension. And a couple of other things that I won't touch on right now, just because it's a
Okay.
little too nitty-gritty for this discussion. But interest, that's going to be growing at a rate of 6% annually. And so the payment plan in this jurisdiction was not helpful in allowing this person to kind of get back on their feet. I mean, the idea is, if you get onto, one thing I didn't mention earlier is that getting onto the payment plan and sticking with it is enough to kind of unlock your license, at least with respect to that jurisdiction. So if you've got 3 and 4 courts, you've got to get into a plan in all 4 courts before you go and turn your license back, or try to turn your license back on. But let's just keep it simple. In this example, there was only one court where this person owed, but this person still couldn't get onto the plan because the terms were too rigid, and this person couldn't kind of meet those terms, couldn't even open the door. Too much time had passed. They couldn't meet the minimum kind of down payment requirements, other problems. And so this person was willing to pay the very small amount of money they were able to collect from various sources that were not employment. This person had to resort to donating their blood plasma, which you get, I think, $20 or $30 every time you do that. And this person was using that just to make ends meet, buy food, and that was it. And so you can imagine they didn't have a lot left over to be paying the court for the time of administering their case. And so this person was just in the classic rock and a hard place, and that's That's what the law should aim to avoid. However, in Virginia, we have a system in which people routinely across the state are in this position.
Well, tell us that you stepped in and you helped this person out.
I don't want to get too specific, but yes, we did intervene on behalf of this person, and their situation is a lot different today. But it required the help of lawyers and a lot of time and effort on their behalf. It's not usual that a person is going to have access to that. I think that this person, just everything kind of aligned for them.
Question I have is employment a requirement to get on this plan?
So employment is not a requirement in any plan that I've seen, but it's a sort of requirement in the sense that, you've got to get your money somehow. And what Sue was mentioning earlier in terms of support, safety net, DSS is not going to be able to provide that kind of just cash assistance. There is no general cash assistance in Virginia. There's, TANF, which is a program available for certain families, low-income families, but that's limited and should go to basic needs, not to paying off your court fines and costs.
Correct.
And so, employment is sort of a hidden requirement. That, or you resort to shaking down your friends and family members for, whatever they can chip in so you can get your license back.
Okay.
Do we really want a system that requires that? I don't think that's in anybody's interest.
Well, we're running out of time, and I guess this is where I say, well, we'll be back to hear some more on this issue. But right now, I'd just like to sum up, and who wants to go first to kind of sum up, leaving with the audience, something that they can take with them. Who wants to go first?
Sure. Well, I'll go first. I think it goes right along the point that I was just making, is that rock in the hard place has got to change. I mean, we need to make sure we have a system where people aren't losing their livelihoods just because they're too poor to pay off their court costs.
Do you have any recommendations or suggestions for our city officials or state officials?
Sure. I mean, there's lots I can think of. I think probably the best way to do it is to either not require people who are too poor to pay to actually pay, or to not suspend their licenses when requiring them to pay is going to impose a hardship on them and their families. That's a no-brainer to me, and it requires some effort on the court's end to look at a person's financial information, but they're used to doing that. They do that all the time when it comes to determining whether a person is eligible for a court-appointed attorney. And in my mind, it just makes sense that we should do the same thing when it comes to court costs and fines, and this person's driver's license and their employment and other livelihood is on the line.
Well, it sounds like this is a request for our delegate, Mr. Toscano, to take up to Richmond on our behalf. Okay. Assistant Director.
I'd just like to say that if you are an ex-offender in the community and you have a question about your court debt or your programs or services that you might be eligible for, to contact us, and we'll make sure that you get the information that you need. And I did want to put a quick plug in for the upcoming Reentry Resource Fair, Saturday, April 30th, sponsored by the City of Charlottesville and the Downtown Job Center. It's going to be held 10 to 1 at the Carver Recreation Center.
I got to wind it up. This is Melvin Burris, your host. This has been the Neighborhood Law Center, and our guest has been Assistant Director Sue Moffitt and Attorney Marlo Salas. Our program has been about the impact of court tests on you, the public, and has been very interesting and informative. We'll come back in July to give you a follow-up on some of the legislative updates that has happened. And I just want to remind you that you can also go to the neighborhoodlawcenter.com on the website to see other programs as well as this one, and on YouTube. Remember, www.neighborhoodlawcenter.com, and click on shows to see this program and others that we have done in the past.